The government says it's a judgment which could put lives at risk. A Conservative MP says it's a victory against a hasty and ill-thought-out law. High Court judges have ruled that an important government act intended to collect information to prevent terrorism and other serious crimes is inconsistent with European Union law. Campaigners say the government will now have to rewrite the Data Retention and Investigatory Powers Act to protect the privacy of innocent people. The case was brought by two MPs, including the former Shadow Home Secretary David Davis, and we'll be talking to him and the minister responsible in a moment. But first, our legal correspondent Clive Coleman is with me. Clive, what is this law and how did it come about?
Well, as you say, it's the catchily entitled Data Retention and Investigatory Powers Act, or DRIPA, as it's known. It's very important. It allows security agencies and, frankly, many other public bodies to gather information from service providers for up to a 12-month period about who suspects, but also anybody, you or I, contact by telephone, by email or internet. It's not the content of the email or the call. It's the when, from whom, to whom, how often and where it was made from. So it can paint a very full picture of someone's life. It can cover, for instance, confidential calls between a lawyer and client, an MP and constituent, and some 500,000 requests are made each year for this data. Now, it was rushed through Parliament by the coalition government, which said emergency legislation was necessary. That was 3 months after a European Court of Justice ruling that existing laws on data retention and surveillance breached individual privacy rights. Now, that angered David Davis and Labour's Tom Watson, who felt that Parliament simply hadn't had enough time to scrutinise this law, and they took the unprecedented step as MPs of challenging primary parliamentary legislation by a judicial review in the courts.
So what did the court rule today and what effect will it have?
Well, it ruled that the Act was unlawful on two bases. One, that it failed to provide clear and precise rules to ensure that data is only accessed for the purpose of preventing and detecting serious offences. And secondly, access to data is not authorised by a court or independent body whose decision, of course, could limit access to and use of that data. And the ruling says the need for that approval to be by a judge or official wholly independent of the force or body making the application should not, provided the person responsible is properly trained or experienced, be particularly cumbersome. Now, the unlawful sections of the Act will remain in force until the end of March 2016 to allow the government time to re-legislate. At that point, they'll cease to have effect. The government says it's going to appeal, and you'll hear why from the Security Minister in a moment.
Thanks very much, Clive. Indeed, we will. But David Davis is one of the two MPs who brought the legal challenge to the High Court, and he's in our Westminster studio now. Good afternoon.
Good afternoon.
Do you feel vindicated?
Well, I'm pleased that the court has ruled as it has. I mean, this, as you heard, this was taken through the House of Commons in one day on an entirely bogus emergency. The government had it for 3 months and actually didn't complete legislating for it for 9 months thereafter. So it was completely bogus, and it didn't allow any debate of what this metadata is used for. Now, when you have the minister on later, you might ask him, can he give you a breakdown of the 540,000 uses of this every year that go on? Because they can't, because we've asked them a number of times what they're for. All I can tell you is that when I pressed my own police authority, they used it for things like traffic offences, amongst other things. So
what has
very important judgment.
What happens now?
Well, we said to the court in terms that we wanted to give Parliament time to revisit this, rewrite the law and get it right this time. And they did that. They've allowed 9 months. I mean, the government gave Parliament 1 day. The court's given us 9 months to get it right. And I cannot believe that we can't do a better job. It also said, as you heard, that it favours judicial prior approval, or at least independent prior approval. And that will improve both privacy but also security. A lot of companies around the world won't give the British government things because they don't believe that ministerial approval or policeman's approval or some other bureaucrat's approval is suitable. And that includes the so-called Five Eyes, all of our intelligence, English-speaking intelligence partners.
Now, as you know, we've got the draft communication data bill coming up, also known as the Snoopers Charter. Should it all be rolled in together, do you think?
There's a strong argument for that. I mean, there is a sort of new consensus arising here. Recently, David Anderson, he's the independent reviewer of terrorism law, produced a report saying that we should bring these acts together. And then only this week, Rusi produced a report saying exactly the same thing. And two of the authors of that report were the past head of GCHQ and the past head of MI5. So, you know, both the sort of civil liberties campaigners at one extreme and the spooks, to put it shortly, at the other, are coming to the same conclusion. This needs independent approval processes that the public can depend on. And so we should bring them all together.
Now, the Minister has issued a statement, we'll be talking to him in a moment, but he says the effect of this judgment will be that in certain cases, communications data that could potentially save lives would only be available to the police if the company's already decided to retain it. I mean, do you think lives are at risk?
No, I mean, we always get this from the government. They tend to play fast and loose with their facts. They don't actually tell you any facts. They make assertions, oh, this is to catch paedophiles or terrorists or whatever. They don't say it's motoring offences. The simple truth here is that the wording is very important. It is said acts to prevent serious crimes. Now, take something like stalking or harassing, which I think the Minister was referring to. They can lead to violence. Indeed, they can lead to murder. So it'd be perfectly legitimate for the government to put them in a list of offences that the act can be used for. Similarly, kidnap's a very obvious case, but also when people go missing, there's nothing wrong with the government saying, no, I doubt any court would strike that down in future, particularly if Parliament had had the time to consider it and come to a measured conclusion, which is clearly not the case here.
David Davis, thanks very much.